Hello and welcome to Sunday Morning Coffee with Dr. Childress here. So today I want to discuss Utah's Ohm's Law, and that's their state variant of the national Kayden's Law. And Kayden's Law was passed by the Congress, and seeking to do certain things relative to the family courts. And if other states or if the states pass supportive legislation, then they get additional money from the government. So this is Utah's version of Kayden's Law, and they're calling it Ohm's Law. HB 272 Child Custody Proceedings Amendment. And so I'll be taking a look at the various aspects of this during today's coffee talk. Starting with Section 3, in which they say, in determining any form of custody and parent time under subsection 1, the court shall consider various things, including C, whether custody and parent time would endanger the child's health or physical or psychological safety. So that they put in psychological safety is significant. So they're clearly indicating that a diagnosis of child psychological abuse, a DSM-5 diagnosis, is clearly specified as a relevant consideration for the court. What's needed is a clear definition of what constitutes psychological safety, because otherwise we're just going to get into all sorts of fights. Professional against professional, competing experts. Is this psychological? We need a clear definition of what psychological child abuse is in the legislation. For all the states, it would be tremendously helpful for the legislatures to provide a clear definition of psychological child abuse in their reporting laws. So when everybody refers back to the definition of abuse, it would be magnificently helpful for the family courts if the legislatures put in a definition of psychological child abuse. And the definition I'd recommend is creating significant developmental, psychological, or psychiatric pathology in the child through pathogenic parenting practices. Pathogenic means producing pathology. So if a parent is producing significant developmental, psychological, or psychiatric pathology in the child, that's child psychological abuse. So that's the recommendation, but it's clear that the Ohm's Law will incorporate psychological child abuse as a consideration. The parent's demonstrated understanding of responsiveness to and ability to meet the developmental needs of the child, including the child's co-parenting skills, so that's a consideration. So a persecutory delusion that prevents the parent from co-parenting or producing a factitious disorder in order to manipulate the court, those would be problematic. Co-parenting skills is substantially problematic, including the ability to encourage the sharing of love and affection. Well, persecutory delusion, creating a factitious disorder would be relevant there. And willingness to allow frequent and continuous contact. Persecutory delusion, factitious disorder would be relevant there. So the concerns of the targeted parent are within the scope of the legislation here. Creating a factitious disorder to manipulate the court's decisions on child custody and creating a shared persecutory delusion in the child is co-parenting and motivations to maintain contact between the child and the other parent. Now note this, except that if the court determines that the parent is acting to protect the child from domestic violence, neglect, or abuse, the parent's protective actions may be taken into consideration. There it is. There's your differential diagnosis. So are we looking at a persecutory delusional thought disorder in the allied parent that's interfering with their co-parenting and their ability to encourage sharing and support? Or are we looking at authentic concerns about the targeted parent relative? So in all cases of custody conflict, we need to do an appropriate differential diagnostic assessment. we're looking at whether the allied parent has a persecutory thought disorder interfering with their co-parenting, or whether the target parent has authentic child abuse requiring a child protection response. There it is. And so that should happen just routinely in all cases, so that we have the necessary information that we have to answer this particular section of Ohm's law. So risk assessment. In all cases of severe attachment pathology surrounding child custody conflict, a proper risk assessment for child abuse needs to be conducted to the appropriate differential diagnoses for each parent. So the targeted parent is abusive. Is the targeted parent abusing the child in some way, thereby creating the child's attachment pathology towards that parent? Or is the allied parent creating a shared or induced persecutory delusion and false, factitious attachment pathology in the child for secondary gain to the parent? The secondary gain is manipulating the court's decisions around child custody and to meet their own emotional and psychological needs, which includes spousal abuse of the targeted parent using the child as a weapon. So we do have spousal abuse going from the allied parent to the targeted parent using the child as a weapon. That happens in the family courts. That's something that Ohm's law participates in, and I'll get to that. But we'll, in all cases, we need a proper risk assessment for possible child abuse pursuant to determining which parent and what's motivating their actions and whether it's justified. Section A, a child may not be required by either party to testify unless the trier of fact determines that extenuating circumstances exist that would necessitate the testimony of the child be heard, and there is no other reasonable method to present the child's testimony. This is good. Children should not testify in the court in support of either parent's time. If we want the child's information, we can get it through therapists or various other sources. The child should not testify to the court. It's too loyalty binding for the child. It puts the child directly in the middle and which is not what we want to do. And the child's views should be collected as part of the clinical diagnostic assessment that we're just looking at, the differential diagnosis for child abuse to either parent. We will gather the child's views during that interview, and that's the appropriate forum for collecting that information. There's family dynamics, there's family influences, family loyalty conflicts. Legal professionals should not be conducting clinical interviews of this sensitivity and of this nature of pathology, where we might have a delusional thought disorder, we might have a factitious disorder, we have all sorts of loyalty conflicts. We need experienced professionals conducting these assessments, not various court personnel or even the judge in this matter. So that's a good thing. No testimony from children. Now, could there be extenuating circumstances? Of course, and so the courts, can extend that as necessary. But as a general principle, children should not be testifying in the courts. Then psychological control definition, and this is one of the primary reasons why they shouldn't be testifying, because their opinions, their verbal reports are being influenced by one of the parents potentially. And so the credibility of the child's reporting is zero. And it just damages so many things within the treatment of the family that it shouldn't happen. So from Barber and Harmon, psychological control refers to parental behaviors that are intrusive and manipulative of children's thoughts, feelings, and attachment to parents. These behaviors appear to be associated with disturbances in the psycho-emotional boundaries between the child and the parent, and hence with the development of an independent sense of self and identity. Psychological control can be expressed through a variety of parental tactics, including guilt induction, which refers to using guilt-inducing strategies to pressure children to comply with a parental request. Guilt induction is used frequently with this pathology. Contingent love or love withdrawal, where parents make their attention, interest, care, and love contingent upon the children's attainment of parental standards. That's used frequently with this pathology. So it's not the parent bad-mouthing the other parent. No, it's very subtle manipulative stuff, very powerfully manipulative stuff. Instilling anxiety, which refers to the induction of anxiety to make children comply with parental requests. That happens frequently in the family courts. And invalidation of the child's perspective, which pertains to parental constraining of the child's spontaneous expression of thoughts and feelings. That happens in the family courts. So you can see here, psychological control is not about overtly saying your other parents are bad, and it's very manipulative in 1,000 different ways. We're dealing with a narcissistic, borderline, dark personality parent. Those are the most manipulative humans on the planet. And so we need to know the pathology that we're dealing with in the family courts. This subsection establishes neither a preference nor a presumption for or against joint physical or sole physical custody, but allows the court and family the widest discretion to choose a parenting plan that is in the best interests of the child. People can do what they want to do. I prefer a rebuttable presumption of equal shared parenting. I think that stops a lot of the conflict, because the concern is that a section like this that puts a wide latitude, it turns the child into a custody prize to be awarded by the court to the better parent based on arbitrary criteria. At least that's the thinking of the narcissistic, borderline, dark personality. If I can prove I'm a better parent and they're a bad parent, then the court's going to give me the child. And so then they start to do all this stuff. Whereas if we just came in and said, no, it's 50-50, unless you can say there's something that doesn't need that, then I think that's better. I think it reduces the conflict, and I think it reduces lawyers and a whole bunch of people litigating and the financial costs. And there's concerns about financial spousal abuse using the court system and the child's induced pathology as weapons. So there's spousal abuse using the child and the courts as weapons that need to be addressed and is not being addressed in Ohm's law here. So in the absence of child abuse, each parent should have as much time and involvement with the child as possible. So that's from clinical psychology, that's the governing principle. In the absence of child abuse, each parent should have as much time and involvement as possible, and typically that works out to roughly 50-50. So I would recommend the court start with there and then rebuttable if there's other circumstances. Abuse. This is a key area that is problematic in Ohm's law, and that needs to be adjusted, and is likely problematic in other Kayden's laws and other legislation relative to this pathology. It's the definition of abuse. So abuse means the same as that term defined in section 81-102. Abuse means non-accidental harm of a child, threatened harm of a child, sexual exploitation, sexual abuse, human trafficking of a child. What we need is a clear definition of psychological child abuse. That would go so far in helping the family courts, and would likely just solve everything in the family courts by giving clear direction to the mental health people as to their responsibilities. So psychological child abuse is creating significant developmental, psychological, or psychiatric pathology in the child through pathogenic parenting practices. If that's put into the legislation, then that's a clear message from the legislatures to the mental health people that they need to be assessing for the developmental, psychological, and psychiatric pathology being created in the child by pathogenic parenting. That's a shared delusion and factitious disorder. So by putting that in that statement or that definition of psychological abuse in the legislation, all mental health professionals will start assessing for delusional thought disorders and factitious disorder imposed on another, because that's psychological child abuse. And so the legislature can, by just adding the definition, the legislature could solve the pathology in the family courts. So adding a clear and guiding definition of psychological child abuse to the definitions of child abuse will resolve the pathology in the family courts by giving clear direction to the involved mental health professionals and the courts. And again, psychological child abuse is creating significant developmental, psychological, and psychiatric pathology in the child through pathogenic parenting practices. That's the definition I recommend. It will solve everything. Domestic violence means the same as a term defined in, now here I would definitely switch to intimate partner violence, which is the professional level term, because that's more grounded in the research and it's more grounded in definitions. And so then domestic violence, that's just too vague a term. for professional level use. So switch to intimate partner violence primarily, especially because we have two different types of intimate partner violence: situational IPV and terrorist IPV. Situational intimate partner violence is where a couple is together and they get fighting and arguing, things get a little out of hand and things moved over a line, or difficult things happen. And that's deeply unfortunate. No, we do not want that. But if we separate those two people and get them out of that, they're not individually problematic. It's just a combination of those two people and the situation got a little out of hand. That's situational intimate partner violence. What we're worried about is the terrorist intimate partner violence. That's your narcissistic, psychopathic, dark personality parent. That's the one we're worried about. And that's the one in the family courts that's using the child as a weapon. Okay, so they're getting the child in an alliance with them and using the child's pathology of, I don't want to be with the other parent, as a weapon of a psychological and emotional abuse against the targeted parent. That's the terrorist one we're worried about. And that's the terrorist one that Ohm's law is actually supporting. So there's Ohm's law is supporting the spousal intimate partner violence of the directed towards the targeted parent by the pathological dark personality allied parent, narcissistic allied parent, using the child as a weapon. And so they're weaponizing the child as a weapon of spousal abuse. And so we switch over to intimate partner violence instead of domestic violence in your legislation terminology, so that we can get grounded in actual research. And it may include an award of exclusive authority by the court to one parent to make specific decisions. This is a good piece, and I would recommend that when there's child protection concerns, that decision making for the child's mental health treatment be given solely to the targeted parent, the parent who has the problem with the child. Who's ever the child and parent-child conflict, that parent should have treatment-related decision, because the other parent shouldn't be messing with the treatment. If the problem is between the child and this parent, that's between the child and this parent. The parent should be making treatment-related decisions regarding their relationship. If you let the other parent start making treatment-related, you're letting them mess with the therapy. And so when you're concerned about something, Your Honor, and there's concerns about child abuse, or there's concerns that treatment isn't going properly and the other parent's interfering with it, give the targeted parent sole consent rights for treatment-related, mental health treatment-related decisions, so that they can fix their relationship. So when child abuse is diagnosed, a normal range parent should be given sole decision-making authority for the child's mental health treatment. Diagnosis guides treatment. So psychological maltreatment means a repeated or extreme incident of caretaker behavior that, so here's their effort at definition: intentionally thwarts a child's basic psychological needs, including physical and psychological safety. Now here we get psychological safety again. That's a vague term. What does that mean? It would be psychological child abuse. And that would be factitious disorder or shared persecutory delusion. So as you're thinking about looking at this definition, where does creating a factitious disorder imposed on a child fall into that? Where does creating a shared or induced persecutory delusion fall into that? It doesn't really. And so they're not addressing psychological maltreatment. They think they are, but they're not. Including physical or psychological safety, cognitive stimulation, and respect. Conveys that the child is worthless, defective, or expendable, and may terrorize a child. Those are more emotional abuse. And so emotional abuse is using high anger parenting or shaming in the situation. Psychological child abuse is creating pathology in the child by pathogenic parenting, because you're kind of so disturbed, you're creating psychotic kind of stuff in your child, a shared delusion. Well, that's psychological child abuse. The other is emotional child abuse. And so general public people, I've worked child abuse, general public people need to get like a little additional clarity on the issues of child abuse. So adding the definition of psychological child abuse as creating significant developmental, psychological, or psychiatric pathology in the child through pathogenic parenting practices will resolve the pathology in the family courts by giving clear direction to the mental health professionals. So, in accordance with Section 3341, when ordering a parent-child schedule, a court shall consider evidence of domestic violence, physical abuse, or sexual abuse involving the child, a parent, a household member, or a parent, and whether the parent time would endanger the child's health or physical or psychological safety. Again, that vague term of psychological safety again needs greater clarity. But this again, that the parent-child time would endanger psychological safety. Well, a diagnosis of child psychological abuse made by a mental health professional for creating a shared persecutory delusion and factitious disorder imposed on the child, that would meet this criteria. So, the court shall consider whether or not there's a shared persecutory delusion, factitious disorder imposed on the child that would endanger the child's psychological safety if the child was sent to be with that parent. But we'll get into that in a second. That's going to be very interesting. So based on this section of Ohm's Law, a proper risk assessment for possible child abuse and possible spousal abuse needs to be conducted to the appropriate differential diagnoses for each parent in all cases of court-involved custody conflict involving severe attachment pathology displayed by the child, i.e. concerns for the child's psychological safety. If a child is rejecting a parent, the only cause of that is abusive range parenting by one parent or the other. Otherwise, the child bonds to the parent. So if a child is rejecting a parent, we're worried about abusive range parenting by that parent or psychological abuse, shared delusion, factitious disorder by the allied parent. So one way or the other, we're concerned for the child's psychological safety. So this section of Ohm's Law would seemingly require a proper risk assessment to the appropriate differential diagnoses for each parent so we can make a decision about this section. Would parent time endanger the child's psychological safety? We need an answer to that question. Let's get it out for a proper risk assessment to the differential diagnoses. A court may consider the following when ordering a parent time schedule: whether the parent time would endanger the child's physical health or mental health. So again, let's get a proper assessment to see if that's true, because that's the assertion of the targeted parent litigant, is that parent time with the allied parent will endanger the mental health of the child. So that's the allegation. So let's get it properly assessed. Now, the allied parent is saying the targeted parent is dangerous. So let's get that assessed too. So let's just routinely get these cases routinely assessed for possible child abuse to the appropriate differential diagnosis for each parent. Why are we fighting about this? Let's just get it assessed, figure out which parent's abusing the child, and get it treated and solved. So this mental health or significantly impair the child's emotional development. Again, psychological child abuse, creating a shared delusional disorder that destroys the child's attachment pathology to the other parent will destroy the child's emotional development, attachment network. So yes, this is definitely directly spot on applicable to the clinical concerns. So evidence of domestic violence, neglect, physical abuse, sexual abuse, or emotional abuse. Notice no psychological abuse. So I would switch out emotional abuse, put psychological abuse. If you want to leave emotional abuse in there, that's fine. Emotional abuse is high anger parenting and shaming. Okay, so those are emotionally abusive parenting practices. The psychologically abusive parenting practices are producing significant pathology in the child. So that's producing a shared delusional disorder, a factitious disorder imposed on another. Those would be psychological child abuse. Okay, so there's a difference. Then significant impair of the child's emotional development. Evidence of domestic violence, neglect, physical abuse, sexual abuse, or psychological abuse involving the child, a parent, or household member of the parent. Psychological maltreatment. So there you get psychological maltreatment. Question for the legislation is, if you don't define that somehow, you're just going to create all sorts of fighting among everybody as to what the definition is. Yes, the targeted parent is psychologically maltreating the child. No, I'm not. And we have competing experts about whether or not this is. Define it. Put it in the legend. Put it that what you mean by that in the argument, and provide clear guidance to the mental health people. So, so Ohm's law clearly makes a child psychological abuse returned by a mental health professional relevant in the court's decision making, and that emotional and psychological abuse are not the same thing. And so that needs consideration in the wording. So, in all cases of child custody conflict involving severe attachment pathology displayed by the child, a proper risk assessment for child abuse needs to be conducted to the appropriate differential diagnoses for each parent. All. And so rather than trying to micromanage these cases from the legislature, telling judges how to make decisions about their cases, let's just get a proper risk assessment for all of these cases, determine which parent with accuracy is abusing the child and creating the child's attachment pathology, and then put it on a treatment plan to fix whatever the problem is in the family. Okay, so let's put it on a treatment plan. Let's fix it. Let's get a proper assessment to get an accurate diagnosis, so we can get an effective treatment plan in all cases, and we can stop trying to micromanage judges and micromanage cases, and just bring the family court pathology to a close. Supervised parenting time. Considering the fundamental liberty interests of parents and children. Yeah, that's good. That's absolutely true. It is a policy of this state that divorcing parents have unrestricted and unsupervised access to their children. I agree with that too. Your family courts use supervision way too often, and it's severely problematic when the pathology is a shared persecutory delusion, because it communicates that the normal range parent is actually a danger to the child when they're not. So by putting a parent on supervised visitation when it's unwarranted, the court is participating in the psychological abuse of the child, because they're communicating that the delusional belief is true. That they've communicating to the child that the court has determined that the targeted parent is a danger to the child. Now, the court may not have determined that, but the child doesn't know that. The child's just going on supervision. Why is a supervisor there? Because that parent's a danger to you. Okay, so with this pathology, we need to be extraordinarily careful about our decision making, which direction we're going, if we don't know which parent is abusing the child. Because if we go the wrong direction, we could be participating in the child abuse. So in all cases, let's get it out, get a proper assessment, get a diagnosis as to which parent, then we can make decisions. If we start making decisions before we know which parent, we're going to get into trouble. So supervised access. When necessary to protect the child and no less restrictive means is reasonably available, however, and in accordance with Section 3341, a court may order supervised parent time if the court finds evidence that the child would be subject to physical or emotional or child abuse, as described in the various sections, from the non-custodial parent if left unsupervised with the non-custodial parent. Yeah, so I've worked child abuse. I'm a clinical director, foster care. So absolutely, if we got physical abuse, supervision, sexual abuse, supervision, the neglect abuse, supervision, a meth addicted parent or alcohol addicted parent, supervision, psychologically abusive parent, that is producing pathology in the child, a factitious disorder imposed on another. Supervision isn't going to have much impact because the psychological stuff just goes right around the physical presence of somebody in the room. The physical presence of somebody in the room can protect against physical assault. They can protect against sexual assault, and they can make sure the parent's sober and is not passing out or something. But they cannot protect against psychological abuse, which just flows right around them because it's in the relationship and the communication, all sorts of stuff. So actually, for the psychological child abuse in the family, shared delusion, factitious disorder, we have to come up with alternatives to supervision. Basically, that's going to be mom or dad for the rest of the kid's life. So we have to help the kid learn the skills to cope with mom and dad. So we can't separate children as a treatment approach. That's not going to work. That's not good. And so at best, we get a protective separation for about 3 months to be able to recover the child without the distorting influence of the parent in there. And then we rip the child apart. Protection. Child abuse diagnosis, we always protect the child. We protect the child. That allows us to communicate that we see that parent as problematic and this parent is normal range. And we restore the healthy development, and we restore with the abusive parent, psychologically abusive parent, with safeguards in place to make sure the psychological child abuse doesn't resume. And there's ways to do that. So that's what we do. But getting this supervision, getting a handle on it, and reducing the amount it's used in the family courts is highly recommended on my part. So here's the guidelines. From clinical psychology to the family courts, here are guidelines from clinical psychology. In the absence of child abuse, parents have the right to parent according to their cultural values, their personal values, and their religious values. In the absence of child abuse, each parent should have as much time and involvement with the child as possible. In the absence of child abuse, to restrict either parent's time and involvement with the child would damage the child's attachment bond to that parent, thereby harming the child and harming that parent. So the only question relevant to clinical psychology, and I would suggest relevant to all the professionals surrounding families and family conflicts, is whether there's child abuse. If there's child abuse, then we protect the child. If there's no child abuse, then parents have the right to be parents. And the people need to kind of stay out of parental decision making and move it into treatment and help the parent develop more effective parenting skills. But it's not a custody issue if there's no child abuse. Now, here's a really significant consideration that the court and all legal professionals and legislatures need to clearly understand about the nature of this specific pathology, a shared persecutory delusion. If the mental health professional and or the court or the legislators misdiagnoses the pathology of a shared persecutory delusion and believes the shared delusion as if it was true, then the mental health professional and or the court or the legislature becomes part of the shared delusion. They become part of the pathology. And when that pathology is a psychological abuse of the child by the allied parent, then the mental health professional and or the court or the legislature become participants in the parent's psychological abuse of the child by validating the child's false delusional beliefs are true when they are in fact a pathology, a persecutory thought disorder imposed on the child. So if we have two possible diagnoses of child abuse and we make the wrong diagnosis, we're going to become participants in the child abuse. So I would ask, the court and all mental health professionals, have you done a proper assessment and are you 100% certain on your diagnosis? Because this is really dangerous if you're not, because you could become a child abuser if you've misdiagnosed the pathology. So that's where we need some really high level professionals over here, because this is way, way important. In addition, if the mental health professional and or the court or legislature believes the shared delusion, then the mental health professional and or the court become part of the shared delusion. They become part of the pathology. When that pathology is the psychological spousal abuse of the targeted parent, targeted for spousal abuse by the allied parent using the child as a weapon, then the mental health professional and or court become participants in the spousal abuse using the child as a weapon. And so that's the important thing to realize about supervision. It should be used cautiously and only based on a confirmed diagnosis of direct child protection need. Otherwise, it's participating in this child abuse and it's participating in the spousal abuse, called Machiavellian manipulation. You have a dark personality who is manipulating the court's decisions by producing pathology in the child, a factitious disorder imposed on another for secondary gain to the parent. Okay? Child psychological abuse. That's the diagnosis. Factitious disorder imposed on another for secondary gain to the parent. The secondary gain is manipulating the court's decisions around child custody. And that's the pathology of concern. And the way they do it is create a shared persecutory delusion in the child. And then that's the way they do it. So, except when the court makes a finding that due to abuse or incapacity of the non-custodial parent, supervised parenting time will be necessary indefinitely to ensure the physical or psychological safety and protection of the child, the court shall, in its order for supervised parent time, provide specific goals and expectations for the non-custodial parent to accomplish before unsupervised parent time can be granted. The court shall schedule one or more follow-up hearings to revisit the issue of supervised parenting time. Yep, that's fine. And giving clear criteria for getting off supervised visitation is always what we need. I've worked child abuse, physical abuse, sexual abuse, neglect abuse. That's where we use supervision. We don't use it so much on psychological child abuse because it's not effective on psychological child abuse. And we just don't want to separate children from long periods of time from parents. So we have to come up with other approaches for psychological. But for physical, sexual, and neglect abuse, yes, if we're going to have to parent on there for a long time, an alcoholic parent, and so it's neglect abuse, and we're going to have to supervise for a long time, we put benchmarks on and say you have to get clean and sober for 6 months or a year or something on your testing, and go to AA all the time, and then we'll have unsupervised time with you. So that's what this is about. And if supervision is used in the family courts, then we need to get clear indications of why it's necessary, what's the danger, what's the physical neglect or sexual danger that's posed. Psychological child abuse doesn't respond to or isn't protected by supervision. So we need a clear indication of what the danger is, and then how do we stop it? What are the criteria for the person getting off supervised visitation? So in a child custody proceeding, if a parent is alleged to have committed domestic violence, switch to intimate partner violence because we got situational or terrorist. And so again, we need to get a diagnosis. And so I'm cautious. I would recommend cautious intervention in obtaining that diagnosis and treating whatever the diagnosis is. Let the mental health people, let the psychology people do what they do, get the information to the court about child abuse or spousal abuse, and then everybody can make their decisions about treatment. Micromanaging treatment is not recommended. So in cases of parents alleged to have committed domestic violence or abuse, including sexual abuse, the court may admit evidence from a court-appointed or outside professional relating to alleged domestic violence or abuse, only if the professional possesses demonstrated expertise and adequate experience in working with victims of domestic violence or abuse. Wait, it should be and abuse. Wait a minute. We've gotten misfocused on this legislation. This is not about domestic violence protection. This is about child abuse protection. We're talking child custody. Is there a risk to the child? And somehow we've gotten off focus in this legislation to making this about domestic violence and punishing the ex-spouse for the marital problems, using the child as the weapon that they no longer deserve a child because they were mean to the borderline mom during the marriage. And so now she's retaliating by saying, you abused me and you were angry with me during the marriage, so you don't get to have your child anymore, and I'm alleging there's domestic violence. Okay, so given that situation, okay, so if there's an allegation or domestic violence, the only experts that are allowed are ones that have expertise in child abuse or domestic violence. No, it's and domestic violence or and child abuse, domestic violence, and including sexual abuse. Why the specific focus on that? Child abuse, physical abuse, sexual abuse, psychological abuse, neglect abuse, all of those are equally damaging to the child. Psychological abuse destroys the child from the inside out. Let me tell you my 5 worst parents, worst, off the chart parents. The top one is sex abuse. Okay, it's sex abuse, incest, off the chart. Be an awful parent. Number 2 is the narcissistic borderline parent. That's my number 2 parent because they destroyed the child from the inside out. Number 3 is my physically abusive parent, the violent parent. Number 4 is my depressed parent, my neglectful parent, my alcohol, suicidal parent. The depressed zone of parent is number 4. Number 5 is the unmedicated schizophrenic or bipolar. So we're talking narcissistic borderline is the number 2 worst possible parent, just behind sex abuse. So why are we singling out sex abuse? We got the psychological abuse by a narcissistic borderline dark personality parent that's equally, maybe not equally, but maybe equally as devastating as the sexual abuse. What we have here is actually a ripple of sex abuse. It's a second generation issue. And that's why you're seeing the fixation of the domestic violence monkeys, flying monkeys on sexual abuse in the family courts and all the false allegations in Gardner, because this is a second generation rippling transgenerational transmission of sex abuse trauma. So we're seeing a lot of the themes. So that's why sex abuse is singled out in the legislation. And physical abuse is just as devastating. Sexual abuse, neglect abuse, that destroys the brain. If you don't feed it, so neglect is horrible, and psychological abuse destroys it. So this is a clear indication that this legislation has been influenced by a distorted perception that has an agenda. So including sex abuse that is not solely of a forensic nature. So they're requiring clinical work with child abuse and intimate partner violence that is, clinical in nature, that includes the zone of sex abuse. And that's the only experts that can be brought in to the matter. Okay, so guess who those experts line up with? The borderline narcissistic or borderline parent, basically borderline histrionic scope, that's making false allegations of domestic violence against the targeted parent, normal range dad. So they make false allegations of domestic violence, and then the only experts the father can bring in this situation are experts about sex abuse and about domestic violence, and they have to be clinical people. Those are the experts of one litigant. The allied parent, borderline mom, wants those experts, and the targeted parent dad is allowed no experts. That's just bias. That's just wrong. This legislation is wrong. Now, interestingly, I meet the Ohm's law restrictions for expert testimony. So I'm not, other than the borderline mothers experts in domestic violence and sex abuse, I'm likely the only other experts that qualified under this. And so this section is substantially unbalanced in favor of one parent litigant who is allowed the expert testimony that parent desires, but eliminates by statute the expert testimony of the other litigant parent without any legitimate justification. So this is extremely problematic. But just to let you know, there's nothing personal about this, is I meet the requirements. And here's the entry on my vita. I was a clinical director for a 3-university assessment and treatment center for kids in foster care. Child Protective Services was our primary referral source. They'd remove a kid from an abusive parent, put them in foster care, and then send them to our clinic for assessment, diagnosis, and treatment. I was in charge of the entire clinic, the clinical operations of it. So I had speech and language out of Redlands. I had occupational therapy involvement out of Loma Linda. I had clinical psychology services out of University of San Bernardino, and I put the whole package together in the treatment of children in foster care. So I have clinical experience in child abuse and domestic violence, intimate partner violence. And so I'm authorized by Kayden's law. And I will say this particular statute needs to be more balanced in its writing to allow both litigants to call relevant experts. And I don't think the legislature should be restricting experts. I mean, just let the parents call whoever they want. The court can look at it and see if it's relevant. Court can decide on credibility. The legislature should not be micromanaging child custody cases. If you get good mental health services and a proper legal system, let them work together and solve the pathology. But the legislature, I would recommend, provides the framework that both of those operate in, but shouldn't be micromanaging things. So I meet Kayden's law criteria. As part of a child custody proceeding, a court may not solely, so pay attention to that word because we'll come back to that, solely in order to improve a deficient relationship between a child and a parent, including in the context of reunification treatment. So, A, remove the child from a parent or litigating party. So if the diagnosis is child psychological abuse by a parent, the court cannot remove the child from the psychologically abusive parent solely because that parent is abusing the child. The legislature is prohibiting the removal of a child from a psychologically abusive parent solely to protect the child from the abuse. We have to come up with some other reason to remove the child from the psychologically abusive parent other than the parent is psychologically abusing the child. Including the context of reunification treatment, remove the child from a parent or litigating party who is competent and not physically or sexually abusive. They can be psychologically abusive. They can be neglectfully abusive. And we can't remove them from that parent. So if the only reason we can remove a child from a parent is physically and sexually abusive parents and with whom the child is bonded. Oh my God, that's a nightmare clause. We're going to have to conduct an assessment on every single one of these kids to determine whether or not the child is bonded to that parent. And then the question becomes, is it healthy bonded? Is it unhealthy bonded? What's the criteria for healthy bonded or unhealthy? Oh, that's just a nightmare. That sentence, that little piece right there, with whom the child is bonded, is a clinical nightmare. How do you assess that? And we're going to have to assess it in every case because that's one of the criteria. So it's just, or restrict reasonable contact between the child and the parent or litigating party. So we can't separate the child from a psychologically abusive parent, nor can we limit the phone calls and contact with a psychologically abusive parent by statute because they are not physically abusive, they're not sexually abusive. Who is competent and with whom the child is psychologically bounded. So the solution is simple. Add the 2 additional child abuse diagnoses. So include not physically, psychologically, sexually, or neglectfully abusive, consistent with the 4 DSM-5 diagnoses. The goal is to protect all children from all forms of child abuse all of the time. You add those 2 words, now boom, we can now protect children from psychologically and neglectfully abusive parents. My question to the legislature and the framers of this is, why did you leave that out? Why are you not protecting children of psychological abuse? And why are you not protecting children of neglect abuse? Why do we have to go in and correct your thinking because you're biased. You're biased to one of the litigants. One of the litigants has gotten your ear and convinced you that you're protecting children and protecting people from domestic violence. And they've gotten a distorted legislation that is unbalanced, that is entirely in their favor, and it allows them to continue their psychological abuse of the child and their psychological spousal abuse of the spouse by legislative statute. Okay, that's significantly problematic. So it's seriously flawed and incomplete wording. Not physically or sexually abusive. That prevents the court from protecting children from parents who are psychologically and neglectfully abusive. The correction is to add all 4 abuse diagnoses consistent with the DSM-5, and it's seriously flawed wording because it's confusing. Child is bonded. What's the definition of bonded? Is only a secure attachment considered bonded? Or is an insecure attachment also considered bonded? How severe an insecure attachment? Is a disorganized attachment a really severe? Is that considered bonded? Well, where on the spectrum of bonded, is it bonded or is it pathologically bonded? This section will require routine attachment assessments to an unclear criteria to determine if a child is bonded, healthy or unhealthy, normal range or pathological, before any decisions can be made by the court, and will introduce competing expert testimony around the poorly defined construct of bonded. Drop it. Just drop it. It's not necessary. Is there child abuse? Do this. If there's no child abuse, do that. We don't need to do an assessment of bonding and think that's a treatment-related issue. Notice how this legislation is getting into treatment and getting into the courts to see. We need framework from the legislature. We need guidance from the legislature. We don't need micromanagement of judges and the treatment providers. But the pathological parent wants the micromanagement, and so they've gotten to some of the legislators to provide that. So here, again, from clinical psychology, these are the recommendations from clinical psychology. So in the absence of child abuse, parents have the right to parent according to their cultural values, their personal values, and their religious values. In the absence of child abuse, each parent should have as much time and involvement with the child as possible. In the absence of child abuse, to restrict either parent's time and involvement with the child would damage the child's attachment bond to that parent, thereby harming the child and harming the parent. So the only question becomes, is there child abuse? Inducing attachment pathology is not treatment. Separating children from parents is not a treatment. Separating a child for any reason other than a child abuse diagnosis is inducing destructive attachment pathology into the parent-child relationship. Diagnosis guides treatment. In all cases of child abuse, physical, sexual, neglect, and psychological, we always protect the child. The duty to protect obligations and professional standards of practice require the child's protective separation from the abusive parent. Okay, so are we clear? We always protect the child. And so when the legislature starts coming in and requiring or prohibiting people from protecting the child, that becomes problematic. And so if you're going to protect the child from physical and sex abuse, protect the child from psychological and neglect abuse as well, all forms of child abuse. In all cases of child custody conflict involving severe attachment pathology displayed by the child, a proper risk assessment for child abuse needs to be conducted to the appropriate differential diagnosis for each parent, all of them. How many currently is this occurring in? Are we getting this? None of them. That should be the focus of the legislature. Why aren't we getting these assessments on all these kids? The differential diagnosis is the targeted parent abusing the child in some way, thereby creating the child's attachment pathology towards that parent? Or is the allied parent psychologically abusing the child by creating a shared induced persecutory delusion and false factitious attachment pathology in the child for secondary gain to the parent of manipulating the court's decisions on child custody? As part of a child custody proceeding where the court has reasonable cause to believe that there is domestic violence, child abuse, or an ongoing risk to the child, a court may not order a reunification treatment or program unless there is generally accepted proof. What's generally accepted proof? Of the physical and psychological safety, effectiveness, and therapeutic value of the reunification treatment. Pay attention to that word. I'm going to come back to it. And that the reunification treatment is not associated with causing harm to the child. A court may not order a reunification treatment that is predicated on cutting off the child from a parent. Key issue, it may not order a reunification treatment that is predicated on cutting off a child from a parent who is competent and not physically or sexually abusive and with whom the child is bonded. So that is exceedingly problematic, with prominent bias towards one parent litigant against the other parent litigant. As part of the child custody proceeding, let me review each section by that. As part of the child custody proceedings where the court has reasonable cause to believe there is domestic violence. So this is being written by borderline personality mothers. Okay, so that's who's writing this, the borderline personality disorder. So they're going to make false allegations of domestic violence against the targeted parent, normal range dad. They don't need proof that there was actually domestic violence during the marriage. They just need reasonable cause. They just need to sow the seeds of suspicion. Then they will use the supposed history of domestic violence. They'll call in their domestic violence experts to say if there's a history of domestic violence, we need to protect the child for various reasons. And so because the mother and father had spousal conflict during the marriage, the mother is going to punish the father by removing his children. And he'll be sorry he divorced her, because now he doesn't have any children anymore because he was abusive to her, domestic violence. Yeah, he yelled at her during the marriage. He called her names, verbal abuse, called her names while they were married. So he doesn't deserve to have children anymore because he's a bad parent because of the domestic violence. That's what's happening in this situation. So the borderline mom variant, she's going to make false allegations of abuse about the marriage. She's going to punish the father for the spousal conflict by taking away his children. That's a DSM-5 diagnosis of spouse or partner abuse, psychological. So recognize that we have spousal abuse of the targeted parent using the children as a weapon. And I would suggest, where in the Ohm's law is that spousal abuse component taken care of? So when there's allegations of domestic violence, I will assert that the targeted parent is making the allegations of domestic violence, specifically spouse or partner abuse, psychological, by the allied parent using the child as a weapon. So now we have two parents making allegations of child abuse. One's about physical or sexual abuse. The other's about psychological abuse and potentially neglect. I'll get into that in a second. And both parents are making allegations of domestic violence, intimate partner violence. The allied parent is saying that they were, sort of your classic spousal abuse kind of situation. And the targeted parent is saying it's psychological spousal abuse using the child as a weapon. So, and that's why we need to go to intimate partner violence. We need to look at whether it's situational or terrorist. If there's terrorist intimate partner violence, that's a relevant consideration, because it's going to be ongoing even after the divorce. And the terrorist IPV is by a narcissistic dark personality person. And so that's an ongoing risk for child abuse if you have a narcissistic dark personality person. Situational IPV is not. It's not a narcissistic dark personality that causes it, and there's no risk once we get the people separated. So it is a situational IPV or is it terrorist IPV? And the legislature needs to stay out of these diagnostic considerations. It needs to prompt for the proper assessment that we get an accurate diagnosis on this information. But stop micromanaging the actual conduct of the custody cases and stop micromanaging treatment, and that's a serious concern. So, as part of the child custody proceedings where the court has reasonable cause to believe there is domestic violence, child abuse, or ongoing risk, so if there's no proven intimate partner violence, it's just a reasonable call, reasonable. So it's not even diagnosed, domestic violence or child abuse, but there's a determination there's ongoing risk. This is so vague. Diagnosis guides treatment. Is there a diagnosis of child abuse? Is there a diagnosis of spousal abuse? If so, then we act on those. If not, then we don't act on them. It's pretty clear. If there's child abuse, diagnose child abuse, and we act on it. If there's spousal abuse, diagnose spousal abuse, and we'll act on it. If there's no diagnosis, there's no thing. Is it clear? That's what mental health should be doing. And that's how we can support the court in these sorts of things. Stop getting in trying to micromanage the mental health people. Or ongoing risk, reunification treatment. Now this is critical to understand. What's the definition of reunification treatment? Here it is from the legislation. Reunification treatment means a treatment or therapy. So all psychological psychotherapy, humanistic existential psychotherapy, Rogerian client-centered psychotherapy, psychoanalytic therapy, Freud, self-psychology, cognitive behavioral therapy, dialectic behavior therapy, solution-focused therapy, internal family systems therapy, all the therapies, all the treatments for everything. It's a treatment or therapy aimed at reuniting or reestablishing a relationship between a child or an estranged, rejected parent or other family. So that's basically attachment therapy. So anything that's designed, any treatment designed to restore healthy parent-child relationships is prohibited. Okay, you can try to go back and say, okay, take a look. It says any of these, reunification treatment is prohibited. You can't order it without demonstrating that it's like not going to cause harm. And they put all these requirements. So internal family systems therapy, if we're going to do that for the family, we're going to have to show that it's not harmful to the children. And that, by what? Where's the research on using internal family therapy with families in family courts? There is none. If we take dialectic behavior therapy and adapt it to the family courts, well, it's for borderline personality disorder. And so, that's not adapted to. We have no proof that it's helpful to the child, and reunification treatment means all therapy, because there's no such thing as reunification therapy. I'm telling you this whole time, there's no such thing. So you're basically eliminating all treatment for the attachment pathology. If there's a breach, ruptured parent-child relationship, we can't do anything. By legislative statute, we're prohibited from treating it unless there is generally accepted proof, what's that, of physical and psychological safety, effectiveness, and therapeutic value of the therapy. So where's the research on internal family systems therapy applied in the family courts? There is none, can't be used. Where's the research on solution-focused therapy used in the family courts and its effectiveness and safety? There is none, it can't be used. Where is the research on family systems therapy in the family courts, that it's safe, effective, and its therapeutic value? There is none, that can't be used. You're eliminating all treatment to restore the healthy parent-child attachment bond. Who wrote this legislation? One party in the litigation who doesn't want the relationship restored with the other parent. So they're prohibiting it by legislation. They're prohibiting any treatment of the attachment relationship. So that's just really seriously problematic. And the court may not order a reunification treatment. That means any therapy. A court cannot order that any therapy be conducted that is predicated on cutting off a child from a parent. Well, what's the treatment for child physical abuse? Separation of the child from the parent. Can't do that. What's the treatment for sex abuse? Separation of a child from the abusive parent. Can't do that because it's based solely on cutting off the child's from a parent. What's the treatment for psychological child abuse? Separating the child from the abusive parent. What's the treatment for neglect abuse? Separating the child from the abusive parent. So the treatment of all forms of child abuse is to protect the child from the abusive parent. This section prohibits the protective separation of children from psychologically and neglectfully abusive parenting by legislative mandate. This legislation is participating in the psychological abuse of children by prohibiting their protective separation from the psychologically and neglectfully abusive parent. Machiavellian manipulation. You want to know what the definition of that term is? There it is. That one party in the litigation, it appears to be the borderline mom variant of the pathology, got a hold of their legislators and presented with the virtuous victim presentation to them and manipulated them into their position to where the legislation is prohibiting treatment for psychological abuse and neglect abuse. How did the legislators get manipulated into prohibiting treatment for psychological child abuse? And if you look at their literature they're putting out, they're saying, oh, we protect from psychological child abuse. Aren't we great? No, you don't actually. You actually prohibit any sort of treatment for psychological child abuse, including protecting the child from the psychologically abusive parent. You specifically prohibit separating a child from we have to leave the child with psychological abuse, which is going to destroy the child from the inside out. It's the number 2 worst parent behind sex abuse. So we're going to just destroy the child's life by legislative mandate of leaving the child with a psychologically abusive parent. So, participation in child abuse. If the legislator, mental health professional, and or the court believes the shared persecutory delusion and as if it was true, then they become part of the shared delusion. They become part of the pathology. And when that pathology is the psychological abuse of the child by a pathological parent, then the legislators, become part of the parent's psychological abuse of the child. The legislator, mental health professional, and or the court become participating child abusers because of their misdiagnosis of the pathology. This is a very dangerous pathology. If the legislators participation in intimate partner violence, terrorist type, let that sink in for a second. If the legislator, mental health professional, and or the court believes the shared persecutory delusion as if it was true, then they become part of the shared delusion. They become part of the pathology. And when that pathology is the psychological spousal abuse of the ex-spouse and now targeted parent, targeted for spousal abuse, using the child as a weapon, then they become part of the psychological spousal abuse of the targeted parent. That the legislator, mental health professional, and or the court become participating spousal abusers because of their misdiagnosis of the pathology. That's kind of important, okay? So by leaving out psychological abuse and neglect abuse from the written legislation, the legislators have been manipulated by one party in the litigant to become participating child abusers in the psychological abuse of the child by the pathological parent creating false, factitious attachment pathology in the child, and the legislators have been manipulated by a borderline dark personality pathology into becoming participating spousal abusers. That domestic violence thing they're talking about, well, the legislators are spousal abusers too. Oh my goodness, they're the spousal abusers using the child as a weapon. Okay, so they are participating with one litigant in the custody conflict to use the child as a weapon of spousal retaliation for the failed marriage because they got angry and fought and called them bad names. That's the domestic violence they're talking about. Back during the marriages, they called them bad names, and got angry with them. And that's the domestic violence. And so now they don't deserve to have a child because they divorced and abandoned me. And said, I need my legislatures to make sure that never happens. And so they'll be punished for their bad spousal behavior during the marriage. And the legislature say, okay, I'll participate in your spousal abuse of the ex-parent. You know how devastating it is to lose your child? That's brutal. That's about the most savage and severe spousal abuse you can inflict on somebody. Take their children away. That parent used to have a child and now they don't have a child anymore. That's savage. And the legislators are in Utah participating in that. They're doing that. They're creating the attachment pathology. They're working to create the attachment pathology in the child, the psychological child abuse that's going to destroy the child's attachment networks and the rest of the child's life. They're participating in that too. Spousal abuse and child abuse, because they left out the words psychological and neglect from the list of abuse that we're protecting from. How did they do that? How did they make that oversight? That they only included 2 of the 4 categories. There's 4 categories of child abuse, and the legislators only included 2 of them, only protecting from these 2, because the other parent wants to protection from these 2. This is bias. This is problem. And so states that are writing your legislation, correct it. Utah, you better go back and correct it, because right now the state legislature is child abusers and spousal abusers participating, cooperative, collateral. So, conclusions. Ohm's law is prominently biased legislation that will favor one parent litigant to the disadvantage of the other parent litigant. Ohm's law will prohibit judges from protectively separating children from psychologically abusive parents. That's a problem. The legislators and courts have seemingly been manipulated by one party in the custody litigation to become participating child abusers and spousal abusers. That's a problem. Reconsideration of wording contained within the legislation is strongly recommended to protect all children from all forms of child abuse all of the time. So my recommendations for Ohm law, and it's relatively simple. So you add a definition of child psychological abuse. So add a clear and guiding definition of child psychological abuse. And I would recommend child psychological abuse is the creation of significant developmental, psychological, or psychiatric pathology in the child through pathogenic parenting practices. That in itself will solve the pathology in the family courts. I would also recommend that you add psychologically and neglectfully for balance to the concerns of both parents. So, and not physically, psychologically, or sexually or neglectfully abusive. That will resolve the issue of you participating in the spousal abuse or in the child abuse, because now you're balanced to the concerns of both parents. One parent is concerned about sexual abuse and physical abuse, typically. The other parent is concerned about psychological abuse and neglect abuse. The neglect abuse is teaching a child not to follow court orders. And if I've got a kid in juvenile justice and I got a parent who's not following court orders and telling the kid they don't have to follow court orders, that's neglect on my side. So if the probation order says you can't be around your friends and the parent's inviting the friends over for parties and stuff, that's neglect from the parent if they can't teach their child to follow court orders. And so we have 2 abuse diagnoses of concern to one litigant, the other 2 abuse diagnoses of concern to the other litigant. We need to be balanced for both the concerns of both litigants. Just simply delete with whom the child is bonded. That's irrelevant and it just creates a nightmare. And delete the mandates on diagnosis, on treatment. You don't need to micromanage treatment or reunification therapy. Don't even get into that. Just say treatment depends on diagnosis. There it is. Let the doctors decide on the treatment. Treatment depends on diagnosis. And if the court can look at the treatment plan and the court can decide things, and we can solve that within the court system, the mental health system, if we have proper guidance from the legislature. So ultimately, the solution that I would recommend to any legislator, and it just takes one, because one will solve the problem, is a pilot program for the family courts. So the solution is a pilot program for the family courts with university involvement for evaluation research to develop the diagnostic assessment and treatment protocols for the appropriate differential diagnostic concerns involved. You got a problem. You need to solve your problem. How do I recommend you solve your problem? I recommend you give it over to your top universities and ask them to solve the problem. We need an accurate diagnostic assessment and effective treatment protocol for the children in the family courts. So let's get that. So task up your top university, come up with a diagnostic assessment protocol, task them to come up with the treatment protocol for this. Task the law school associated with the university to come up with the legal arguments in support of the treatment, the diagnostic treatment protocols being developed. It can be done. I'd estimate a 2-year pilot program, 1 year, 6 months of planning, 1 year of implementation, 6 months of data review and report writing. And then we would have a diagnostic assessment protocol we could use across the nation and everywhere. And internationally, it would be established, and then we could revise it as necessary going forward. But we would have a clear solution to the problem. So you want a solution, pilot program for the family courts with university involvement for evaluation research. And that's true in any state. Pick your top university. That's true internationally. Pick your top university, put in a pilot program, and let's get a solution. Let's stop fighting about it and let's get a solution. So with that, I'm going to head out to my Sunday. So about an hour and 15 minutes. So this is a long seminar, but valuable seminar. So you know where I am, and I'm just going to hang around. I am an authorized expert under Ohm's law, under Kayden's law. I have clinical background in child abuse and intimate partner violence. And so, these are the recommendations of one of the experts that you have identified as being an expert, that the legislation is severely biased and needs review and correction. So with that, I'm going to head off to my Sunday, and good luck to everybody out there.